Digital Rights and Freedom Bill has as its core objective to protect the fundamental freedom of every Nigerian online. It touches on important areas in the current digital environment, which includes data and digital privacy, lawful interception, surveillance, e-governance, freedom of information, opinion and expression online in Nigeria. One of Nigeria's foremost activists for an inclusive online environment in the country, Mr. Gbenga Sesan, speaks on the bill, which has passed second reading at the House of Representatives, and its implications for Nigeria.
It will be important for the process to continue. It's a good bill, obviously. It's not even just a good bill, it's a great bill. It's one that spells out the rights of citizens in terms of data privacy, in terms of making sure that surveillance is not a problem, making sure there's nothing like internet shutdown. I mean, no government can wake up tomorrow and say, you know what, we don't want people to cheat in exams, we don't want you to announce election results, like the excuses that governments have given. I mean, this is preemptive. This is proactive protection of digital rights in Nigeria. After it goes through that, then it goes back to the House of Representatives, where there's a third reading and possibly a vote. Those two stages are very critical. That public hearing and that third reading, because if it passes in the House, then it can go for concurrence in the Senate. That's another critical step. And then assent with the president. So we've got about 4 stages to go.
Despite the death of the anti-social media bill in the Senate, you always raise a case in terms of the Nigerian laws governing the cyberspace. What are those issues that you identified, and what needs to be done to ensure that nothing infringes the rights of Nigerians when it comes to social media relations?
I speak specifically to the cybercrime law, actually. It's not a bill anymore, it's not a law. It was signed by President Jonathan in May 2015. Section 24 of that law is literally the senior brother of the frivolous petitions bill that was killed. It makes the same provisions, it just punishes more. Where it says 2 million here, it says 3 million there. Where it says 2 years jail here, it says 7 years jail there. And that's one. This other thing is Section 38 of that bill gives security agencies too much power without judicial oversight to gain access to your data or my data, which means that if I don't like your face and I'm in government and I'm powerful, I can use that law against you. Section 24 has already been used by a bank MD, has been used by a governor against innocent citizens. And these are the things that we say, we've gone to court. By the way, we've gone to court, joining the National Assembly and other people who are implementing the law, the police and all that, to say that these 2 sections of this law need to be removed. Of course, that means either of 2 things. Either that, if we win the case in court, it means that those 2 sections will then become, a subject of that court case and can be used, to arrest or jail anyone and things like that. And the second option is for the National Assembly to say, you know what, we've seen this, we don't want this court, case to go on and all that. We will amend this law and we will remove those 2 sections. Whichever way, as long as the goat gets to the, goat and yam are very bad examples to give here. As long as the horse gets to the river, then we've been able to achieve making the horse drink.
With the stage set for the public hearing on the bill, it will be expected that all stakeholders will work assiduously to guarantee Nigerians' online freedom.